Okay, we're live on YouTube now.
Nobody's with you just yet.
Not yet, no. Somebody will show up. And meanwhile, it'll be on there and we'll have it recorded.
They won't pick our voices though, right? Because it's too far away.
It might. I mean, I could move the laptop over there and then you guys...
I just want to know if I say anything, if I'm going to be heard. That's all.
Well, you might be heard a little bit.
Okay.
So this is a notice of constitutional challenge. And then after we're done talking about this, if we have time, we'll talk about my response to the Court of Appeals. My case is now in the Court of Appeals. They sent me a letter. And we'll talk about my response to that. So this is a brief, 6:39, we're a little bit early. This is a brief in support of notice of constitutional challenge under the federal rules of civil procedure. Under Rule 5, you have to give them notice that you're challenging something constitutionally. So I filed a notice of constitutional challenge when they assaulted me with their minor estate, when the judges, the bought and paid for clerks masquerading as judges, assaulted me with their minor estate. So I figured, okay, see, it really doesn't matter what you say, and I can show you why. There's actually a court case. Let me see if I can find it. It's oh, let's do this. There. I sent this out to you guys. You remember getting it there, Ken? I think I sent it to you. Sent it to Nelson and sent it to a bunch of people. Let me see if I can find it here. So at least we understand what's going on. It's been a while since I sent this out. There we go. Well, this is one of them. Let's share this. Okay, so this is Supreme Court, Luther versus Borden. Let's make this bigger. This is one of them. When a state forms a constitution which is approved by Congress, it's a stop to deny its invalidity. The action of Congress cannot be inquired into, for the judicial is bound to follow the action of the political department. So, and that's U.S. Supreme Court, Luther versus Borden. Anyways, so that's, so you think of that, then that minor estate, Congress passed a law about the minor estate. The only way we can defeat it is we got to challenge this constitutionality through the courts. Otherwise, they're going to presume that we're the minor estate. And that's why you see all the injustice in the courts nowadays. Anyways, that's why I sent them a nasty gram. You lying, perjuring, because they have an oath of office, so they can't sit there and use their presumptions to see what I'm saying? Anyways, don't get me going. You're going to get me going.
How do you challenge the minor estate in court?
Sorry?
How do you challenge the minor estate in court?
You got to file a notice of constitutional challenge, which is what I did in this case. It's now going to the Court of Appeals, so it'll be in the Fifth Circuit, mine, and then to the Supreme Court. And I'm challenging the constitutionality of the minor estate and the 1871 corporation. And I'm going to throw in about the state bar too, the National Bar Foundation, because those are all foreign agents of the Vatican. And so they have, that's again there, and we'll go through the same rationale in this notice of constitutional challenge. So we'll go through that first. Let me just check online and make sure that, oh, there's some people here already. So what we're talking about, see the minor estate, once Congress, as we talked about a minute ago, is once Congress passes a law, and in Canada be the same way. Once Parliament passes a law about the minor estate, they presume you're the minor estate until you challenge the constitutionality of it through the courts. Otherwise, you're the minor estate. So I'm not sure how you would challenge it in Canada, but in the U.S., I know exactly how to challenge it, thanks to this whole cantankerous old fart Bill that was here. And he's not here right now, but he's the one that pointed it out, and I thought it like the lights came on. And I'm telling you, he was 100% right. Anyway, so this is a brief in support of the Notice of Constitutional Challenge pursuant to your Color of Law Rule 5. They're all color of law. I like to get in their face. So comes now demandants providing notice to the bought and paid for clerks masquerading as judges in this inferior legislative court that their executive branch congressional handlers in the District of Columbia, that their 1871 corporation at 16 Stat 419 located in the District of Columbia and its minor estate scam are violations of the organic laws as found in there are as follows. There's 4 organic laws for the United States of America: the Declaration of Independence, the Articles of Confederation and Perpetual Union, the Northwest Ordinance, and this Constitution for the United States of America. The District of Columbia 1871 municipal corporation is a violation of the organic laws because it is Roman law from the Vatican. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action whichever particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law, which violates Article 1 in Amendment, which requires Congress shall make no law respecting an establishment of religion. And this is the Vatican. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That's the First Amendment. And is bringing the Vatican's Roman law onto the land of America, which uses fraud and deception to supersede and replace common law. And there's no common law offenses against the United States, only those acts which Congress has forbidden with penalties for disobedience of its command or crimes. Under Texas law, no act or omission is a crime unless made so by statute. The legislature may create an offense and in the same enactment provide exceptions to its application. As found in the cause of necessities for taking up arms in 1775, which means the War of Independence was fought over this. Statutes have been passed extending courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and estimable privilege of trial by jury in cases affecting both life and property, to supersede the courts of common law, instead thereof to publish and order the use and exercise of the law martial. And there's a bunch of other stuff that I use out of this, but this is what's relevant for this matter. So the War of Independence was fought over this. There's also talked about some of the reasons for the separation from the tyrant in the organic law of the Declaration of Independence. He's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation, for transporting us beyond seas to be tried for pretended offenses. That right there is directly talking about that minor estate. For imposing taxes on us without our consent, that's talking about that minor estate. For depriving us in many cases of the benefits of trial by jury. For taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our government. That's the D.C. Corporation. He's abdicated government here by declaring us out of his protection and waging war against us, and that's exactly what they're doing. I had somebody contact me today about she was being in Pennsylvania. She'd been attacked. And I told her, first of all, the number one rule is you got to understand you're at war, okay? They are your enemy, okay? They are treating you like their enemy by what they're doing. Okay, so you got to understand that they are the enemy, and you never ever tell the enemy what you're going to do. So anyways, so that's exactly what's going on. It's warfare, because common law is the law of the land, which has always been here. The citizen may stand upon his constitutional rights as a citizen. The individual, his rights are such as existed by the law of the land long antecedent to the organization of the state. That's long before the organization of the state. That's Hale versus Hinkle, 1906. And it is full of fraud and deception, satanic, which is the same reason why we took up arms against the Vatican's tyrant, and for all the grievances listed in the organic law of the Declaration of Independence. The minor estate that the county of Montag and their Vatican's bar members and their Vatican's bought and paid for clerks masquerading as judges have assaulted the demandant with is also a violation of the organic laws under Article 1 and Amendment, which requires Congress shall make no law respecting an establishment of religion. And we already went over that, the First Amendment. The minor estate was created by the Vatican. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. For when they were driven out of all of their former holes, they devised a new method of conveyance by which lands were granted, not to themselves directly, but to nominal fiefs, to the use of the religious houses, thus distinguishing between the possession and the use. Use being usufruct under Roman law. And the receiving the actual profits, while a season of the land remained in a nominal fief who was held by the courts of equity, then under the direction of the clergy. Isn't that convenient? The Roman cult runs the courts. To be bound in conscience to account to assesticate use for the rents and emoluments of the estate. That's taxes, folks. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And that's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mort main. And by the Vatican's tyrant, with the Sesta V Act of 1666, Chapter 11, 1819, which was for land titles, which was brought into America, and the Code of Law, with the Code of Law for the District of Columbia, 31 Stat 1432, where it says, the legal estate to be a necessitary use, which is talking about land titles, and a use is short for usufruct under Roman law. Those things which perish by capitis diminutio, or which kind are usufruct, an obligation service on a part of a freeman contracted by oath, and matters enforceable by a statutable action. And that's the commentaries of Gaius, the rules of Ulpian, translated in 1874, which is a type of a trust. And the U.S. citizen minor estate entity is a taxpayer. Every taxpayer is a cesticate trust having sufficient interest in preventing abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. And that's a summary out of that case. Citizens of the United States is a civilly dead entity operating as a co-trustee and co-beneficiary of the public charitable trust, the constructive cesticate trust of U.S. Inc., under the 14th Amendment, which upholds the debt of U.S. and U.S. Inc., and that's a summary out of 5 pages of the congressional record, okay? So don't anybody come to me saying, I can't find that. Well, you're a brain-dead idiot if you do, because it's not in there. It's a summary. Hello? Anyways, the Vatican's minor estate was also talked about as some of the reasons for the separation from the Vatican's tyrant in the organic law, the Declaration of Independence. And we already read that stuff. And is found in the Cause of Necessities for Taking Up Arms, 1775. And that's the Cause of Necessities for Taking Up Arms. To supersede the course of common law, instead thereof to publish the order of use of exercise of the law martial. Janet Yellen and her predecessors used the Vatican's fraud and deception and their minor estate entity. Now I say that the heir, as long as he's a child, differeth nothing from a servant, though he be Lord of it all. And that's Galatians 4:1. To use it as justification to assault the demandant with the Commerce Clause under Article 1, Section 8, Clause 3, in violation of Article 1, Section 8, Clause 17, to assault the demandant with a quasi-contract. Assumpsit, in its origin an action of tort, assumpsit was soon transformed into an action of contract, being afterwards a remedy where there was neither tort nor contract, based at first only upon an express promise. It was afterwards supported by an implied promise, and even upon a fictitious promise. Introduced as a special manifestation of the action, and in case it soon acquired the dignity of a distinct form of action, which superseded debt, became concurrent with account, with case upon a bailment, a warranty, bills of exchange, and competed with equity in the case of essentially equitable quasi-contracts. Growing out of the principle of unjust enrichment, surely it would be hard to find a better illustration of the flexibility and power of self-development of the common law. And that's Bar Members, The History of Assumption, 1909. Both in Romish and English law, there were certain obligations which were not in truth contractual, but the law treats as if they were. They were contractual in law, but not in fact, being the subject matter of a fictitious extension of the sphere of contract to cover obligations which do not in reality fall within it, which requires the Vatican's minor estate, a U.S. citizen, 31 CFR 363.6, or other fiction. Constructive quasi-contracts are based solely upon the legal fiction or fiction of law. So the Vatican's bar members in the county of Montague can assault the demandant with their Texas tax code with their forced rendition, which is why they use the Vatican's fraud and deception of capitis diminutio. Remember, we were talking about that up here. Those things which perish by capitis diminutio. Capitis diminutio is the destruction of the caput of the legal personality. Capitis diminutio, so to speak, wipes out the former individual and puts a new one in his place. Between the old and new, the individual, there is legally speaking nothing in common. A juristic personality may be thus destroyed in one of three ways: by loss of status libertatis. This is the capitis diminutio maxima. By loss of status civitatis. This is the capitis diminutio media. and by loss of severance from the agnatic family. This entails capitis diminutio minima. And this is a textbook of the history and system of Roman private law. Black's Law Dictionary, 8th edition. Capitis diminutio maximum, meaning the maximum loss of status through the use of capitalization. The highest and most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, when he became a slave. It swept away all the rights of citizenship and all family rights, and that's Black's Law Dictionary, 4th edition. Because the Vatican's fraud and deception, a capitis diminutio maxima is used when they enslave people, and they are Satanists using fraud and deception to sell people into slavery as collateral for the minor estate. He, the prisoner, has as a consequence of his crime not only forfeited his liberty, but all his personal rights except those which the law and its humanity affords him. He is for the time being a slave of the state, which are non-judicial proceedings, because whenever a statute's involved, the Vatican's fake judge is actually a bought and paid for clerk masquerading as a judge. When acting to enforce a statute and a subsequent amendment, to the present date, the judge of municipal court is acting as an administrative officer, not in a judicial capacity. Courts administrating and enforcing statutes do not act judicially, but merely ministerially, but merely act as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. It's the accepted rule not only in state courts, but of the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a bought and paid for ministerial clerk for the agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature, and otherwise act as mere clerks for the involved agency, which is why it's a bill of pains and penalties, and similar to a bill of attainder, and a violation of the organic law. This Constitution for the United States of America, Article 1, Section 10, Clause 1, and Article 1, Section 9, Clause 3. A bill of attainder means legislative acts, no matter what their form, that apply either to named individuals or to easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. So when they issue an order of commitment, that is actually a legislative act. Bill of attainder, a special legislative act prescribing punishment without a trial for a specific person or group. Bills of attainder are prohibited by the U.S. Constitution. It's not a judge. It's not a court. It's a legislative act. Bill of pains and penalties. A legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. Bills of pains and penalties are included in the U.S. Constitution ban on bills of attainder. Also means they have no authority to do anything judicial and are fraudulently and deceptively presenting themselves as a court of law. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Their legislative inferior court might be a superior court of general jurisdiction under some circumstances. A court of general jurisdiction is presumed to be acting within its jurisdiction till the contrary is shown. But when a superior court of general jurisdiction undertakes anything that is in derogation of common law, it becomes quad hoc an inferior court of limited jurisdiction. To be the statutes that would deprive a citizen of the rights of person or property without a regular trial according to the course and usage of common law would not be the law of the land. And their maritime codes have absolutely nothing to do with common law. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceeding. And that's found in Book 21, a Corpus Juris Secundum, Section 2, Courts. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, a decision made in the exercise of such power is treated as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply. And that's Book 20 of American Jurisprudence, 2nd edition, Courts, Section 103. It is familiar law that when special statutory authority and derogation of common law is conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc a court of inferior or limited jurisdiction. Therefore, it's actually an administrative hearing for their maritime court. A ministerial act is an act that a public officer is required to perform in a prescribed manner in obedience to the mandate of legal authority and without regard to his own judgment or opinion concerning such act's propriety or impropriety, when a given state of facts exists. Discretion, on the other hand, has power conferred on public functionaries to act officially according to the dictates of their own judgment. When acting to enforce a statute and in subsequent amendments to the present date, the judge of municipal court is acting as an administrative officer and not in a judicial capacity. Courts administrating or enforcing statutes do not act judicially, but merely ministerially, but merely acts as an extension, as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. It's the accepted rule not only in state courts, but in the federal courts as well, that when a judge is enforcing administrative law, they're described as mere extensions of the administrative agency for superior reviewing purposes, as a bought and paid for ministerial clerk for the agency. Judges who become involved in enforcement of mere statutes, civil or criminal in nature and otherwise, act as mere clerks of the involved agency, which is a fraud and deceptive, satanic, because it's actually an executive agency working for the executive branch.
So Glenn, you're bringing these up to discredit the trial court on your appeal. Is that right?
This is part of the notice of constitutional challenge. Okay, so I'm explaining why that minor estate and the District of Columbia Corporation are both unconstitutional, because they bring Roman law onto the land of America. Okay, and so the minor estate, they're both created by the Vatican. And Roman law is the Vatican's law. In Europe, they have a European common law. There's a common law of Italy, too, believe it or not. There's books that talk about it. So Roman law is law from the Vatican. That's where it is. It comes from the Vatican.
And he's using the Constitution because, remember, the establishment of religion, they can't establish a religion.
They can't. Congress shall make no law respecting an establishment of religion. And if you understand the debates that went on, they debated over every word that was going to be in those first 10 amendments in the Constitution itself. The word administrative is synonymous with the word executive. The word administrate connotes of or pertains to administration, especially management, as by managing or conducting or superintending the executive application or conduct of persons or things. Thus, administrative acts are those acts which are necessary to be done to carry out legislative policies and purposes already declared by the legislative body. In fact, it is common to use the two words in tandem. So I'm toying around with filing a Rule 11 emergency petition with the Supreme Court. Thinking about that, actually. So we'll see. I'll probably go ahead and do the appeal stuff and get the appeal done. And then I'll probably go ahead and start working on the emergency petition, because it'll be, once I did it for the Court of Appeals, it'll be very similar for the Supreme Court. You see what I'm saying? And the Supreme Court has different rules. I've been there, 5 times so far, so this will be number 6. And this will be so it'll be pretty similar, which is full of fraud and deception, because there's no judge for that proceeding. Is actually a bought and paid for clerk masquerading as a judge that cannot do anything judicial. Ministerial officers are incompetent to receive grants of judicial power from the legislature. Their acts in attempting to exercise such powers are necessarily nullities. Where there's no jurisdiction, there's no judge. The proceeding is as nothing. Such has been the law from the days of Marshal Saya. To put the demandant into bondage, selling the demandant into slavery, is collateral for the Vatican's minor estate, as described in 31 CFR 363.6. Because an entity includes the estate of a living person, such as an incompetent or a minor, and entity means any owner of a treasury direct account that's not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, or professional limited liability company, trust, the estate of a decedent, or the estate of a living person, such as an incompetent or a minor. And a minor can be an individual who's attained the age of 18 years but has not yet taken control of the securities in his or her minor account. Minor means an individual under the age of 18 years. The term minor is also used to return to an individual who has attained the age of 18 years, but has not yet taken control of the securities contained in his or her minor account. They are fraudulently and deceptively use the Vatican's minor estate to bring in the District of Columbia outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as made by session of particular states and acceptance of Congress, become the seat of government of the United States, which is using the Vatican's fraud and deception to unlawfully place the demandant under the Commerce Clause, Article 1, Section 8, Clause 3, and this is National Mutual Insurance Company versus Tidewater Transfer Company. In other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia, and through their plenary power nationally covers those citizens, even when in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. So, and then if I was to add something in, I'd add some stuff in about plenary, because that's a dictatorship. Okay, there's no due process in plenary power. This is why the Vatican's bar members are name-calling the demandant a sovereign citizen like it's a bad thing when they know the House Joint Resolution 183, dated May 3rd, 1940, at 54 Stat 178, says in the preamble, whereas it's desirable that the sovereign citizens of our nation be prepared for their responsibilities and impressed with the significance of their status in our self-governing republic. And the Vatican's bar members are required to know that the Supreme Court of the United States has ruled that everyone and everything not privileged is sovereign. The rights of sovereignty extend to all persons and things not privileged that are within the territory. All of which evidences their intent to perjure their oath to support the supreme law of the land, Article 6, Clause 2, and make war on the Republic and engage in all the reasons for the separation from the Vatican's tyrant in the organic law of the Declaration of Independence. This is prohibiting the free exercise of the demandant's religious beliefs in violation of Article 1 and Amendment. Congress shall make no law respecting established religion or prohibiting the free exercise thereof. As a Christian, because the demandant has a right to own land under natural laws found in the Holy Bible. Every citizen and freeman is endowed with certain rights and privileges to enjoy which no written law or statute is required. They are fundamental and natural rights recognized among all free people, which is satanic because the Vatican is a necromancer with their minor estate, bringing dead things to life, and prohibited under God's laws found in the Holy Bible. There shall not be found among you anyone that maketh his son or his daughter to pass through the fire, that useth divination, or an observer of times, or an enchanter, or a witch, or a charmer, or a consulter with familiar spirits, or a wizard, or a necromancer. For all these things are an abomination unto the Lord, for they are abominations to the Lord thy God, doth drive them out from before thee. That's Deuteronomy 18:10-12, and they're using fraud and deception of the Vatican's minor estate to engage in the theft of the demandant's land and populate prisons by selling people into slavery. If a man be found stealing any of his brethren of the children of Israel, maketh merchandise of him or selleth him, then that thief shall die. Thou shalt put evil away from among you. And all fraud and deception comes from the devil and Satan. You're of your father, the devil. The lust of your father will do. He was a murderer from the beginning and abode not in the truth, because there is no truth in him. For when he speaketh a lie, he speaketh of his own, for he is a liar and the father of it. I know the blasphemy of them that say they are Jews or Christians and are not, but are of the synagogue of Satan. So if I added anything in there, I'd add in about the bar members, okay, the National Bar Foundation, because that's unconstitutional. That's an act of Congress. And what happened is in 1947, there was a bar treaty of 1947, but that really only applies in the District of Columbia, but it's still unconstitutional. And because the bar members are everywhere, you know, and they sit there and they lie through their teeth. How can you tell they're lying? It says right here in John 8:44, your father, your level of the devil, the lust of your father will do. He's a murderer from the beginning and abode not in the truth, because there is no truth in him. So every time his lips are moving, he's lying. Okay? That's what it comes down to. They're liars. Anyways, so that's basically my brief. I have this here, and I'm probably going to add some stuff to it when I go. I've already filed this in the district court, and so the file document is going to go to the Court of Appeals. But I'll probably modify it when I get into the Court of Appeals and start making my briefs and stuff like that. Okay, so let's see what the comments are here. Yeah, it's all complete corruption. It's because it's the Vatican. It's all, they're all Satanists. And the sooner we figure that out, matter of fact, quite frankly, I'm not going to espouse this on YouTube, but I wouldn't be surprised to see people start stretching the necks of these bar members. I mean, that's if we're a Christian nation, then that's what we're going to have to do. We got to put this evil away from among us. And these people are selling people into slavery, and they need to be put to death. But I certainly don't think that they shouldn't be given due process of law. They should definitely get due process of law. And so, and I'm glad the decision's not up to me. That's just my opinion. Anyways, but if at some point, we're going to have to, if we're a Christian nation, we got to be a Christian nation. And if not, then we're going to reap the judgments of God. I think that's part of what's going on right now. But anyways, I'll pull up what the Court of Appeals sent me, and then I'll pull up what I sent them. Let me find it here. Oh, there it is. So this is what the Court of Appeals sent me for my appeal case. Took them a while. The mail's slow. I tell you, the mail's real bad these days. Anyways, so this is a letter, March 14th. They gave me the case number. Filings with the court are governed strictly by the federal rules of appellate procedure. We cannot accept motions submitted under the federal rules of civil procedure. We can address only those documents the court directs you to file or proper motions filed in support of the appeal. You must pay the district clerk $605. So anyways, I'll show you how I responded to this. And I've done this before too. All counsel who desire to appear in this case must electronically file. Well, I'm not going to electronically file, so I responded to that too. So I sent him a notice of response. It says here, if you're filing pro se, you can request to receive correspondence from the court and other parties by email, and can also request to file pleadings through the court's electronic filing system. I can request. I don't have to. Details explaining how you can request this are available. And that's talking about highly sensitive documents. Seeking documents, our court has a strong presumption of public access. This is just talking about stuff that's sealed. And they sent it also to all these other people. So, anyway, so then this is my response. I sent them this. This is actually what I responded. I filed in the lower court too, and it was crickets. Never heard a peep out of them. So this is my response. United States Court of Appeals for the Fifth Circuit responds to the District of Columbia Corporate Clerk's impecuniosity interrogatory and electronic filing agenda. Impecuniosity interrogatory. The demandant will gladly complete the impecuniosity interrogatory when the District of Columbia clerks, masquerading as judges, when they provide a bona fide Article 4 an amendment search warrant signed by an Article 3 judge with a court seal as required by the Authentications Act, requiring the demandant to provide any personal information based on probable cause of a crime supported by oath or affirmation of competent witnesses, fails to be a government employee, and must include the specific information required. And this is the Fourth Amendment. And then the electronic filing agenda. The demandant will gladly collect the electronic filing requirements for the District of Columbia clerks masquerading as judges when they provide the law that requires the demandant to get or use a Social Security number for their electronic filing in order to get a credit card, when they provide the law that requires the demandant get or use a credit card or a debit card or even a bank account for their electronic filing agenda, when they provide the law that requires the demandant to get government-issued identification papers or plastic as required by the bankster buddies, as required by their District of Columbia electronic filing, when they tell Yarborough and Simonton to arrest and prosecute the bankster thieves for their felonies when they close the demandant's bank accounts for failure to provide a Social Security number and failure to provide a government-issued identification, when they provide their authority to convert the demandant's right to justice in this matter into a privilege, when they provide a bona fide Article 4 and Amendment search warrant signed by an Article 3 judge with a court seal as required by the Authentications Act, requiring the demandant to disclose the Social Security number or disclose the credit card number or bank account number or name, address, or government-issued identification for their electronic filing agenda. The demandant's a living man fails to have a Social Security number that banksters require for a credit card or a bank account. The demandant's a living man fails to have a credit card or debit card. The demandant's a living man and fails to have a bank account. The demandant's a living man and fails to have a government-issued identification card that the banksters require, mostly because the demandant fails to be a government employee. The demandants filed felony criminal complaints with Chad Yarborough and Leah Simonton and their predecessors against Coinbase, Wells Fargo Bank, Frost Bank, Bank of Texas, Regions Bank, Comerica Bank, Compass Bank, PNC Bank, and TD Bank for their forced KYC Know Your Customer Social Security number and government-issued identification requirements after they closed the demandant's account, some of which have been in place for many years, for failure to provide Social Security number or government-issued identification, and Yarborough and Simonton and their predecessors absolutely refused to do anything about it. The demandant did file a suit against Wells Fargo Bank in the lower so-called court as case number 414 CV 853A, and the clerks masquerading as judges dismissed it for failure to pay their District of Columbia Securities, Federal Reserve notes, IOUs, forced loans, extortion, evidencing their intent to sell their just us, and justifying the refusal of Yarborough and Simonton and their predecessors to prosecute the felonies. The fact that the officers of the sole court are demanding their impecuniosity interrogatory and their electronic filing scam is proof they failed to be lawful Article 3 judge, but are actually bought and paid for administrative clerks working as judge, masquerading as judges, thereby disqualifying themselves, giving that the issue in this case are core issues involving life, liberty, or property. And there's a bunch of court cases saying that only Article 3 courts can deal with life, liberty, or property. And then it goes on. It says the demandant has lots of first-hand knowledge of how the officers of this so-called court intend that these wrongdoers named herein and others engaged in the theft of the demandant's land, because then they can justify forcing the demandant to give evidence against himself to force the demandant into their satanic commercial District of Columbia dictatorship. So either way, it's a win-win-win scenario for their Satanist Bill priests, officers of this District of Columbia so-called court. The demandant has lots of first-hand knowledge of how the officers of this so-called court intend that the wrongdoers named herein and others engaged in multiple felonies and enslave the demandant because it brings them so much business, and because they can then assault the demandant with their District of Columbia commercial dictatorship with their fake money and their bankster thieves and their electronic filing scam, so they can justify assaulting the demandant with the minor estate treasury direct account and enslave the demandant and steal the demandant's land. The demandant demands that the District of Columbia clerks in this corporate so-called court provide relief against their U.S. citizen wrongdoers named herein. And there's some court cases. By regulating their property as required under Article 4, Section 3, Clause 2. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States. That's Article 4, Section, which is the supreme law of the land, anything in the constitutional laws of any state to the contrary notwithstanding. That's Article 6, Clause 2. This Constitution shall be the supreme law of the land. The judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. But they're acting as accomplices, busy fabricating evidence, assaulting the amendment with their Commerce Clause, Article 1, Section 8, Clause 3, with their electronic filing scam, evidencing their intent to bring their District of Columbia dictatorship outside a maximum of 10 miles square in violation of Article 1, Section 8, Clause 17. But it's nothing personal. It's just business. Assaulting the amendment with their color of law minor estate, and then the Satanist bail priest can call it a contract. Failure of the bought and paid for clerks masquerading as judges in this District of Columbia so-called court to do their duty to regulate their corporate property, Article 4, Section 3, Clause 2, and failure to vigorously prosecute them for their felonies might result in the defendant resisting their slavery scammer with lethal force if necessary by hunting the wrongdoers down to complete a commercial transaction by blowing their fucking brains out, since they want to do a commercial transaction so bad, and call that a contract. And if the wrongdoer is killed and demanded, then when he resists their slavery with lethal force if necessary, the Satanist bail priest officers of the so-called court get to pillage all the fake money in the minor estate treasury direct account for themselves and their thieving bankster buddies, bankster handlers under the Hague Convention concerning the International Administration of the Estates of Deceased Persons, concluded 2nd of October 1973, which is what they've intended from the beginning, as evidenced by the minor estate treasury direct account, which is a dead thing, which means that it's a win-win scenario for the officers of the assault court and their bankster handlers, which evidences their refusal to prosecute the 78 felonies because it has absolutely nothing to do with the law, which these Satanist bail priests have nothing but contempt for, but it's political. And they're giving aid and comfort to the enemy in a time of war, and when the demandant turns up dead, this document will be the demandant's deathbed testimony. The demandant's not suicidal, but he's also a cantankerous old fart and has lots of aches and pains, and the sooner he's out of this fucking hole, the better. With thieves everywhere, especially in the fake governments and government employees that perjure their oaths at the drop of a hat, and the bought and paid for clerks masquerading as judges in this so-called court, and the demandant's conscience clear, he's ready to meet his maker. So go ahead, make my day. We're all here before this universe is created, and we'll all be here when it goes away, before God, angels, and anyone who reads us as a witness. The demandant shakes the dust of the earth to mop his feet against these wrongdoers named herein, and the officers of this District of Columbia so-called court, Matthew 10 and 14, Mark 6 and 11, Luke 9 and 5, and we'll all be talking about this before the judgment seat of the true God on Judgment Day. And that's the end of that one. It's kind of I get the railing on that. Anyways,
you get a response back on that?
No. There won't be any responses. And then there's my Form 1020. See, they wanted $605. And I actually did this before, too, and it worked. This is my Form 1020. Let me... show it on YouTube. I did this before and it worked.
You got the whole thing paid?
So they don't respond for each one, right? Because they just not ask for the fee anymore?
I never hear a peep out of it again.
But then they let you file.
Of course. Of course. There won't be an electronic filing, and they'll deal with it. Anyways, so this is also what I sent. This is my Form 1020. This is Carrie Zolman's Form 1020, and it's brilliant. I give Carrie all of the... This is only the first one, so I've got the other two ready to go. The notice of default and opportunity to cure, and the final notice of default. And so this is going to the clerk, the chief judge of the U.S. Court of Appeals for the Fifth Circuit, the circuit executive. Did you know they have a circuit executive? I guess that's kind of like a CEO.
Sounds like it.
Yeah, right. And David Godby is the chief judge of the Northern District of Texas. Notice to attorneys at United States Court of Appeals for the Fifth Circuit. The notice here. United States Court of Appeals for the Fifth Circuit, a private corporation.
That's good.
An attorney for a private corporation is assumed to know the law. It's the obligation of attorney for a private corporation to see that any alleged fines, fees, charges, etc. are collected lawfully, correctly, and completely. In order to correctly, quote, pay this alleged fines, fees, charges, etc., GlennWinningham House of Fern requires the following information from attorneys at United States Court of Appeals for the Fifth Circuit. Complete this form and return it to the address you have on file to enable GlennWinningham Fern to understand and lawfully comply with this alleged fines, fees, charges, etc. This form raises formal questions with regard to his alleged fines, fees, charges, etc., that only your attorneys can answer. Under the caption, you must pay the district court clerk what does the number 605 refer to? Obligations of the United States government, national bank currency, bonds, certificates of indebtedness, Federal Reserve notes, bills, or other. Explain. I need to know what it is. I want to pay. Does the statement refer to consideration of obligations or other securities of the United States directly or indirectly? Check 1. Does the computation of this alleged clerk letter require consideration of obligations or other securities of the United States directly or indirectly? Yes or no? Most individuals can complete this form in 3 minutes. You're required by law, UCC 3-104 and 3-115 to complete this form before any payment may be made. As a private corporation, you're assumed to know the law, not misleading. You made several statements in your clerk's letter to GlennWinningham House of Fern that GlennWinningham House of Fern owes something to someone. It's your obligation to answer the foregoing questions on Form 1020, or a default will be issued by GlennWinningham House of Fern against United States Court of Appeals for the Fifth Circuit, a private corporation, for trying to mislead GlennWinningham House of Fern by asking GlennWinningham House of Fern for something that he doesn't know, or you don't know what that something is. So as attorneys, you're assumed to know the law. And then I'm an attorney at the United States Court of Appeals for the Fifth Circuit, a private corporation. I've read the foregoing 1020, and I know it to be true, correct, complete, not misleading in any way. I declare under penalty of perjury the foregoing is true and correct. Executed on day, name, sign, and bar number. This Form 1020 must be completed and returned within 15 days of mailing, delivery, filing. Failure to complete this Form 1020 in 15 days will result in default being prepared for the United States Court of Appeals for the Fifth Circuit based on the information GlennWinningham House of Fern has, and the default is your admittance that the fines, fees, charges that was provided by GlennWinningham House of Fern was an error or in violation of law, and no other mailing will be needed. Failure to provide GlennWinningham House of Fern with the requested information and the time allowed, the attorneys at United States Court of Appeals for the Fifth Circuit are admitting with their silence that the United States Court of Appeals for the Fifth Circuit is dishonest. Estoppel arises where a person is under duty to another to speak, or failure to speak is inconsistent with honest dealings. Silence by United States Court of Appeals for the Fifth Circuit will be treated by GlennWinningham House of Fern that fines, fees, charges, etc. as dishonest dealings, and balance is paid in full. And that's it. And then it's got the clerk's letter attached. And so I sent both of these by priority mail. It cost me $19 for each one. And the post office is slower than a 7-year itch. And so anyways, and so what happened last time, see, they give you 14 days to pay the filing fee, right? So what happened last time is it went way beyond the 14 days. And after I did the 3 steps, I didn't hear a peep out of anybody. And after I did the 3 steps, they sent me the scheduling order.
What's the scheduling order?
The scheduling order is when they tell you that you have to have your appeal brief done by a certain day, and the appellees have to have their appeal brief done by a certain day, and if you want to respond to their appeal brief or anything like that.
So it's as if it was filed then.
Yeah, exactly. Yeah.
And that works because of HJR 192, right?
I don't know. It might. I don't know. I've heard that HJR 192 has been repealed, but so at any rate, so that's what I filed.
Well, the main thing there is that they only federal employees, state employees can use Federal Reserve notes.
Yeah, that's right. Yeah. So I'm telling them, I'm just asking them, tell me what to pay. I want to know what to pay. And so I got the notice of default ready, or it's just about ready. I've got to make a few minor changes like the date on it and stuff, but I'll show you what I'm going to send them for the notice of default. Okay, this is the notice of default. Let's make it big. Notice of default and opportunity to cure.
You never ever have had anyone respond back.
No.
All the different bar members.
No, never. This is a notice of default and opportunity to cure. You are in default of providing a specie of payment. You're notified that your attorneys have failed to complete the Form 1020 that was filed on April 14th, 2020. And actually, that'll change because I got to wait until I know they've received it. I check online. See what I'm saying? And so it'll be the date they received it. And this date will also change. This will be in April, or maybe it'll be the last of March. It's hard to say. But so these are going to change. But that's about the only thing that's going to change right now. Oh, yeah, and these numbers are the right numbers. I've attached a copy with proof of service for your reference. This is giving me great evidence against you and your Roman cult handlers and your intent to engage in multiple felonies, violating rights and immunities under color of law, conspiracy to threaten, intimidate, coerce, injure me in the free exercise of my rights, mail fraud, sending threatening mail, impersonation, perjury of oath, and more. This is an effort to pay an alleged debt, and I'm going to give you another 5 days to provide a specie of payment as required by Form 1020 that was served on you, or you are required to discharge this alleged debt under your Uniform Commercial Code 3.603. Have a great day.
I think you.
I'd
like to see you get out of town. You're a threat to them. Don't let you get over you.
So we'll see. Anyways, so yeah.
Okay, to the first floor. Okay, bye.
So, so that's what I am going to do. And what I'll do is I'll attach the complete package that I sent them already with my proof of service. The certified mail website, USPS website. I print off the USPS website, and I have the green card. And if the green card gets back, if it doesn't, then that's okay. I don't worry about it. But I have that green slip from the certified mail showing that I sent it, and the USPS website showing it was delivered. See what I'm saying? Yeah. If I get the green card back, that's fine. If not, the post office is really lousy. It's just really lousy. And so there was a guy at the post office today that was saying that, and it wasn't the postal clerk, and the postal clerk was getting all upset. And I said, no, I don't think it's anything you guys are doing. You guys are doing what you normally do, but I think it's what's happening at the main post office and how they're delivering it. And because it used to be, and I told him, I said, it used to be that I could put something in the mail here in Fort Worth and it'd be on the other side of Dallas on the same day. Really, it used to be. Used to be it'd get that far in one day, you know, and it used to be it'd get across 3 states over a weekend. You know what I mean? And so. And that was regular first class mail. That wasn't priority mail or anything like that. Anyways, and I said, I don't think it's anything you guys are doing because you're just receiving it and getting it on its way, you know. But anyway, so the post office has really gone downhill. So, anyways, is there any questions on YouTube? I'm not seeing any. Oh, yawn. I'm not seeing any. So what I'm going to do on that challenge, constitutional challenge, I'm going to bring up the bar, and I'm going to bring up the plenary. there's court cases about plenary, because it says right in that court case that it's a plenary jurisdiction in the District of Columbia. And so well, they have to take an oath of office. Matter of fact, I've heard some rumors that they're going to be going quo warranto on a bunch of members of the House of Representatives, senators, and governors, and removing them. I've heard that that's going to happen. I've heard the governor of Colorado, the governor of California, and there's other ones. Utah. I heard the governor of Utah is going to get removed.
Yeah.
And so that's a rumor.
Quo warranto, is that because the votes weren't valid?
Yeah. I've heard that that's what's going to happen. So we'll see, So we all got to do what we can do. And I'm doing what I can do. And so I've done this stuff before. And you should see my petition, the lawsuit that I filed. I was going off on them. What did allege you did? I don't know what you're talking about. What did they allege you did? Well, they stole my land is what they did. And whether they alleged anything or not, they stole my land. And so I'm going to break it off in their ass. They say that it costs $2 million. See, now it's going to get expensive because all these lawyers are going to have to hire appellate attorneys now. That's going to cost them some money. It'll cost them $100,000 if it costs them a nickel. I guarantee you. To go to the Court of Appeals? Absolutely. And then when it goes to the Supreme Court, I had when I went to the Supreme Court the first time, I had this lady that worked at U.S. Airways said to me, she said, "You know how much this is costing the company?" So I went, and in my next paperwork, I filed in there as something about it's none of her. She's not supposed to be talking to me about that, and but there's no doubt it's cost them some major money. They say it cost $2 million to go to the Supreme Court.
Wow.
So I don't know. I don't pay that. Matter of fact, I don't even pay filing fees. Nelson's not here today. Nelson is on, what would you call it?
He's in Arizona.
Yeah, he's in Arizona. I would call that, what would you call that? I had to think about what I'd call that. Yeah, they stole my land and then they demanded extortion to get it back, and I wound up paying the extortion to get it back, and that's when I sued them. And now it's their worst nightmare. It's going to cost them way more than any extortion they ever got.
You're going to wish they never would have done it now.
Yeah, I told them. I said, I've been to the Supreme Court 5 times, and you're next. You know how much it costs to go to the Supreme Court?
2,000.
No, I've told them that.
Oh.
I didn't say. I just told them that.
Yeah.
Now they're going to find out.
They'll find out. Sure left your land alone.
Yeah, they messed with the wrong guy. So, but that's okay. I'm going to challenge the constitutionality of this minor estate, and I think that's the root of all evil, really. I think that's going to be the number one problem. That's going to be the number one problem that we're all experiencing is that damn minor estate and that DC corporation. So all of that's going to come to an end. Matter of fact, they say the Brunson brothers they say Congress, a remote viewer said they saw Congress adjourning for the last time, and they were thinking it was because of the Brunson brothers. And so, I don't know. Maybe it will be, but it also could be because of my case. Because if I say the DC corporation is unconstitutional and they have to dissolve it, then that means Congress is adjourning for the last time. See what I'm saying? If they have to dissolve that DC corporation, Congress will adjourn for the last time. So, anyways, yeah, I don't know. I have no idea about elected officials. I can tell you that Obama is going to get impeached. They can be impeached even when they're out of office. So they might be in there. It might be a lifetime thing unless they get impeached. That's entirely possible. Solicitor General review of February 20th, 25. I don't know. I've heard that there's a new one in there that Trump appointed, and that they have notified that they're not going to defend administrative courts. And so I hope so. I hope that's the case. I guess we'll see what happens when I get to the Supreme Court, because the Solicitor General will have to take the case. And so I guess we'll see. I think they're going to have to defend that DC corporation and the minor estate, although I don't know how they can defend it. But I guess we'll see. Well, yeah, they're not wanting my property anymore, but think about it. They were getting ready to sell it in an auction. Okay, they didn't sell it in the auction. They were getting ready to sell it in the auction. So then think about it. If they're getting ready to sell it in an auction, that means they stole it.
Yeah, they sure do. They're really in trouble.
And so, they canceled the auction.
I know they screwed up. That's why
I haven't heard a peep out of them since. And now it's going to the Court of Appeals. And it's going to cost them a hell of a pile of money. I paid $2,000. It was over $600 or $400 in property tax. And I wound up paying $2,000. And it's going to cost them millions.
You assume in their personal capacity.
Yes. And they're fucking judges. They're bought and paid for a horse.
So they can't use the county money.
Well, I did. Oh, they're still using it. The Attorney General defended him. Matter of fact, my next lawsuit, I'm naming Paxton in his private capacity, because he wants to defend all these people being sued in their private capacity. So Paxton, you can come to the party now. I was going to add him to this one, but they wouldn't let me. They only let you do First Amendment petition, demand for relief, right? And I tried to do a second one, and the judge said you got to get approval from everybody else to file it, and they wouldn't approve it. And so, anyways. Yeah, that's interesting. In Haiti. So I don't know how Haiti works. I don't know if that's common law. I think that's like satanic, actually. They do these satanic ceremonies there for sure. So I don't know how much Satanism is affecting their law. I know there was a bunch of Haitians that were in Illinois. I'm reading some of the comments on YouTube. Anyways, is there anything anybody else wants to cover? I'm pretty well out of stuff for today. Maybe I went through it too fast. So, Yeah, I'm going to modify this and add in the National Bar Foundation, the brief in support of the notice of constitutional question, and I think I got a pretty good case to get that overturned, because it's definitely created by the Vatican, and I don't think they're going to ever be able to dispute it. The England went and passed that Sesta KV Act, and these, like, Nelson's busy trying to get access to it, and I think that's like major mistake. But I don't do anything with the minor estate, so I don't know why. Don't be asking me about that stuff. I don't do that. If you're thinking that the money in that minor estate is yours, it's not. It belongs to the government. You might have an interest. It's a usufruct is what it is. But it's Roman law. You're in a contract with the devil. I don't know if you want to be in a contract with the devil. I'm not interested in being in a contract with the devil. I want nothing to do with it. I told him in my federal court case that I want the damn thing dissolved and liquidated, and I don't care what you do with the fake money. You can put it up your rectal orifice. I said that right in my. I don't care what you do with the fake money. You can put it up your rectal orifice. For all I care. You can justify it any way you want. That's called rationalization. I wonder how that's going to look on Judgment Day. So I'm just trying to think of what else we can cover here today. So I did this first I did this first Form 1020, and the second one, you saw how I'm going to do it. It will have this first one attached, and then the third one will be a final notice of default, and it'll basically say all the same things. It'll be on one page. I think I can get it scrunched in on one page, and it'll have the first two attached, and it'll say I don't owe you anything, and then they'll send me a scheduling order. So we'll see. I got to, in the meanwhile, I have to prepare the record because I didn't do electronic filing. Then I have to send a CD with the record, with my record, to the Court of Appeals, so they have a copy of that's everything that I filed into the lower court. And but notice this: they're using non-domestic mail, so it's not in the United States. They don't, and it's GlennWinningham, which is kind of interesting because my ancestors, if you look at my pedigree chart, my ancestors, it's all Winninghams that go back before the War of Independence. It's on the Winningham side of the family. And so it's all Winninghams that go back before the War of Independence. But on one of my lines back there was a William Todd Livingston as my fifth great-grandfather. And his son, Will Livingston, was the governor of New Jersey, the first governor of New Jersey. and he ratified the Constitution for New Jersey. So that makes me posterity. You see what I'm saying? In the preamble.
Why did they send it non-domestic mail?
Because I tell them to.
Who you tell?
Yeah, that's my address. I also put down zip code exempt too, and they didn't do that, but at least they're doing non-domestic mail, so that's okay. Domestic mail's in the District of Columbia. Although they did give me the title of nobility too. The Mr. So, anyways. So we'll see what happens. It's all satanic. Well, they went and rose up in rebellion, and think about it. That's why I put in there that maybe I'll hunt their ass down and blow their fucking brains out. Actually, what I should have said is maybe I'll follow after the traditions of my forefathers and hunt their fucking ass down and blow their fucking brains out. He obviously wasn't loyal to the king. They told him to take a hike. It's kind of interesting that Benjamin Franklin, his son, was one of the governors of the colonies, and when the Declaration of Independence happened, they arrested him. And they had him in jail. They held him in jail until ultimately he went back to England, because his son's wife, was one of the aristocrats in England, So, there's a lot of stuff that's going on. It's kind of ironic. So we'll see what happens. That's all I can say. So I've got my, I have to prepare the record. I got to, matter of fact, I've got everything I need. I just have to organize it and prepare it, put it on a DVD, on a CD, burn it onto a CD and send them the CD.
Was there any hearings in the trial court?
No, it's all done on paper. There never is. I've never. When I file a lawsuit, I've never been in any hearings or anything. So, but look at they're sending it to all of these respondents. Now they're all going to have to hire appellate lawyers. So we'll see. Notice they buy the deputy clerk. How they signed that?
Yeah.
You see that all the time. But at least they say, I mean, it's legible anyways. You can see that it's legible, but they're printing it there too. So they're trying to be proper, and I think that's good. They should be proper, completely proper. You know what I mean? If there's any place that it should be proper, it would be in the courts. The some of these court cases is just so improper. The stuff that's going on is just, like with this Robert Dunlap that we're helping. he did a bunch of things to really sabotage himself bad. And anyways, yeah, don't get me going. So all these lawyers, yeah, so Nathan Hecht is the former chief judge of the Texas Supreme Court. He resigned. So this is the official caption right here. So good. They get their liars. So I'm going to bring up a bunch of stuff. And then this is going to lay the foundation for my next lawsuit. I've got another one I'm working on. But I want to wait and see what happens with this first. But it's nice that they're basically holding my hand, or at least it seems like it. Maybe they do that with everybody. Nope, they're all right. Glenn Heger, who is the comptroller, Texas comptroller, suing his ass. Ten Harrelson is the chief appraiser, suing his ass. He's the one that that did the forced rendition. And there's actually the et al. Means that there's a bunch that aren't on here. Yeah, these two whores, Jack McGahee and Patricia Coleman Byers. Are the whores. Well, I meant the judges. No, the whores. The bought and paid for whores. So I guess if that's about it, maybe we should cash it in. Do we have anything else that we want to talk about? It's kind of early. We started early though.
Yeah, there's a deal with you, small claim, a receipt.
I think what we'll do is we'll cash it in. We started early.
A lot of stuff going on.
This has been going on for an hour and a half.
You know, that small claims thing.
So I guess we're going to end it early, I think. It's only 8 o'clock, so we actually have about another hour we can go, but we got here early. We started early. Did you take care of everything you wanted to do?
Mm-hmm.
Are you going to meet him again tomorrow?
Maybe Friday.
Oh, okay.
Are you live right now?
Yeah.
We'll just wait till you get through.
Okay. So I think that's about it. I think I'm going to cash it in. We started early tonight and we're going to end early, but we've been going for about an hour and a half. And so thanks everybody for watching. This is a work in progress. If anybody has any questions, now's the time to ask them. Otherwise, we're going to go ahead and cash it in for the night. I pretty well covered everything I wanted to cover.